I've been given conflicting advice. Half the people that I have spoken to told me to stand up and say I am Tom Wicker, and the other half said stand up and say I'm not. Actually, unfortunately, Tom Wicker was unable at the last minute to join us, and so I've been asked to pinch hit just to be sure that the panelists stay on the schedule that we've arranged, and then to help coordinate questions and answers. This is the first panel in your program, Models of Common Law Decision Making, and we have the Honorable Richard Willard, who is the Assistant Attorney General of the Civil Division in the Department of Justice, Honorable Stanley Mosk of the California Supreme Court, and the Honorable Grover Rees, Chief Justice of the High Court of America, Samoa. And what I will do is turn the podium over to Mr. Willard, and then Judge Mosk, and then Judge Rees will each give 10-minute remarks, after which we can open it up to a more general discussion. Mr. Willard.
It is an honor to be here today on this program and this panel to discuss models of common law decision making. My thesis is that the traditional method of the common law is totally inconsistent with the modern practice of judicial activism. Now, we're all accustomed to hearing about judicial activism in the context of constitutional law or criminal law, but although less well known, it is equally a phenomenon in the field of civil law. Indeed, our common law disciplines of property, torts, and contracts have been revolutionized by a generation of judges engaged in social engineering. A particularly bald-faced apology for this practice is found in the 4th edition of Prosser on Torts, in a chapter conveniently headed Social Engineering. After describing adjudication as being a process of weighing the interests of the plaintiff against the interests of the defendant, Prosser goes on to say that when the interest of the public is thrown into the scale and allowed to swing the balance for or against the plaintiff, the result is a form of social engineering that deliberately seeks to use the law as an instrument to promote the greatest happiness of the greatest number, which by common consent is the object of society. And he goes on to say that this process, while carried particularly far in the law of torts, has permeated all fields of the law. Now, it is no accident that Prosser cites Bentham's utilitarian formula as the object of society. Bentham's vision and the vision of the judicial activists is antithetical to the way of the common law. This conflict is well illuminated by Professor Sowell in his new book, A Conflict of Visions, of which I hope we will be hearing more shortly. Professor Sowell relies on Oliver Wendell Holmes to outline the common law method. Holmes, as we remember, says the life of the law has not been logic, it has been experience. Later, Professor Sowell relates the clash between the common law method and judicial activism to fundamentally differing visions of the nature of man, one constrained and one unconstrained. Today, what I would like to do is to explore this conflict of visions by looking at a particular development in the law of torts, the trend to liability without fault. This is not, by the way, a new trend. Even early in the 20th century, legal theorists were speculating about the possibility of imposing liability without fault, perhaps stimulated by the advent of worker compensation legislation. However, for the first half of this century, our courts universally followed common law doctrines that limited tort liability to situations where innocent plaintiffs had been injured by the foreseeable consequences of a defendant's negligent or otherwise wrongful conduct. The real assault on fault-based tort law doctrines was led by Yale law professor Fleming James. His view and their impact have been well described by Professor George Priest, who noted that James' vision, while not original, in fact, William O. Douglas had written earlier on this topic in ways that foreshadowed James's views, was really particularly influential because James pursued his vision of tort law with a radical single-mindedness. Priest says, the single idea on which James' tort scholarship was built was the role of personal injury damage judgments as a form of social insurance. James saw accidents as inevitable consequences of productive activity, and he conceived the principal function of tort law to be compensation of the injured. He was very concerned about the consequences of serious personal injury on the lives of victims, most particularly the poor. James believed the direct answer to the problem was to shift losses from these plaintiffs to defendants able to spread them broadly over society by insurance or by adding a small increment to the price of their products. Now, the first glimmer of judicial acceptance of Fleming James' theories was provided in 1944 by Chief Justice Roger Trainor's famous concurring opinion in the exploding Coke bottle case, Escola against Coca-Cola Bottling Company. In often quoted language, Justice Trainor announced this theory. He said, the cost of an injury and the loss of time and health may be overwhelming misfortune to the person injured and a needless one, for the risk of injury can be insured by the manufacturer and distributed among the public as a cost of doing business. 18 years later, in Agreement against U.S. Power Products, Justice Trainor's view was announced in his opinion as the law of California. And only 2 years later, the American Law Institute, under the leadership of reporter William Prosser, remember the guy I quoted on social engineering, adopted this as Section 402A of the Restatement of Torts. Now, I'd like to note that I don't necessarily disagree with the concept of strict liability as defined in Greenman and the Restatement of Torts. That is, liability imposed on a manufacturer for making a product that is defective and unreasonably dangerous. Because in my view, that's not a concept far removed from negligence and is still a fault-based concept of liability. But of course, this kind of strict liability doesn't go all the way for Fleming James. His avowed goal was to achieve a system that imposed absolute liability. And so he and the courts pursued many other doctrinal developments to expand vastly the liability imposed by the tort system, such as the abolition of doctrines like contributory negligence or assumption of the risk. As James made it clear, this was part of his transitional plan to achieving absolute no-fault liability. The one technique used for this is by using the language of a fault-based system while actually imposing de facto no-fault liability. And this technique I thought was particularly well described by Louis Jaffe, who, by the way, taught me torts 15 years ago at Harvard Law School, although I didn't adequately appreciate his wisdom at the time, since I sat in the back of the class and viewed it as an arcane subject. But going back and reading his articles now, I can see the wisdom, which I should have appreciated 15 years ago. In an article in 1953, Professor Jaffe observed that even where the law still insists on the syntax of fault and speaks this language, it may characterize as negligent conduct which by the earlier legal standard or by present colloquial standards is quite innocent. He went on to discuss a recent railroad liability case in which an employee was alleged to have tripped on a clinker or a piece of coal present on the railroad way, and the Supreme Court held that this presence of the clinker was a sufficient allegation of negligence. Now, Jaffe says he knows of no one who would view the failure to remove a piece of coal from the railroad way as a failure to observe the dictates of neighborly regard. Jaffe says the clinker is a point d'appui, a concrete entity around which it is possible to spin the speech of negligence. Now, since the days of Escola and Greenman, the California Supreme Court, under the leadership of such nationally renowned jurists as Chief Justice Trainor, Matthew Trebriner, have led the way in realizing Fleming James' goal of expansive tort liability. And what I'd like to do now is look at a series of recent vintage California Supreme Court cases to see that while the court still speaks the syntax of fault, uses the language of negligence, the meaning is something altogether different. Let's start with the telephone booth case, Bigby against Pacific Telephone. Many of you have heard of this case. An apparently intoxicated driver lost control of her car and veered off the road, jumped a curb, crossed the sidewalk, went into a parking lot, and hit a phone booth 15 feet from the roadway. Now, it's not surprising the man who was standing inside the phone booth and was injured filed a lawsuit. You might be surprised to know the suit was filed against the companies responsible for the design, installation, and maintenance of the phone booth. And the California Supreme Court, in an opinion by Chief Justice Rose Bird, found that the risk someone might veer off the road and crash into this particular phone booth was not unforeseeable, and therefore a jury would be permitted to find the defendants liable. She found it was of no consequence the harm came primarily as a result of the recklessness of the intoxicated driver. And in a concluding footnote, she states, and I'll quote excerpts from the footnote, "There are no policy considerations which weigh against imposition of liability, even though the defendant's conduct may have been without moral blame," and goes on to refer specifically to the probable availability of insurance for these types of accidents. Now, some people have tried to defend Chief Justice Byrd's opinion in this case by pointing out there is an allegation that the telephone door jammed as the plaintiff tried to exit, thus preventing his escape from the oncoming car. But it's important to realize that her opinion was not limited to the sticky door, which was mentioned only in passing. Her primary rationale was that liability could be based on the fact that the phone booth was located only 15 feet away from a busy roadway. As Justice Croninger's partial dissent points out in the case, public telephones have in fact long been maintained adjacent to public streets and highways for the convenience of the public, and it is unreasonable to regard such locations as a basis for imposing liability. The court's approach for allowing liability to be based on foreseeability is a recipe for virtually unlimited liability, since with 20/20 hindsight, almost any accident is foreseeable. Now, I'd like to mention several other cases which are similar for their holding. Palma against U.S. Industrial Fasteners. A truck was left unlocked overnight in a company parking lot with the keys in the glove compartment. It was stolen. The thief ran over someone. The injured person sued the company that owned the truck. In the California Supreme Court, an opinion by Justice Joseph Grodin found that the jury could find a company liable based on the finding the circumstances presented an invitation to theft by persons not competent to safely operate the trucks and who might cause serious injury or damage to third persons. So here we have the doctrine of foreseeability as a two-part test. The first part being it's foreseeable someone might steal the truck if you leave the keys in the glove compartment overnight. The second part of the test being that if someone steals a truck, they might not be a very safe driver and might injure a third party, and therefore liability can be placed on the company. The last case I'd like to mention is the Condominium Rapist case, decided only a few months ago. The plaintiff in this case was raped and robbed by an assailant who entered her condominium under cover of darkness. California Supreme Court, in an opinion by Justice Broussard, held she could not sue her condominium association and the individual members of its board of directors for injuries sustained in the assault. In this case, as in Bigby, there were two theories of liability, and one being an allegation of misfeasance with which I have no particular quarrel. The court also went on to hold liability could be based on non-feasance, that is, the failure of the board to adequately investigate inadequate lighting in the housing project and to propose a plan to resolve the project. Justice Mosk's dissent points out the flaw in this theory, and I'll quote, "To reason from the foreseeability of harm to the existence of a duty to prevent such harm, again begs the question," argued that the directors of the Condominium Association should not have been held liable. Now, we may wonder, and perhaps Justice Mosk will be able to tell us why he did not dissent on the same grounds from the phone booth case or the stolen truck case. Because I think all of these cases are tied together by the same common thread. In each case, there was a real wrongdoer, the drunk driver, the truck thief, the condominium rapist. And in each case, the California Supreme Court engaged in a search for a surrogate wrongdoer, someone who had the deep pocket, the resources to compensate a plaintiff, and in so doing distorted the traditional tort doctrines, the language of fault, in order to impose liability. And if you think that I'm exaggerating, we can look at the language of another case, Huntington Memorial Hospital, involving an attack in a hospital parking lot. In that case, the court said, "Surely a landowner should not get one free assault before he can be held liable for criminal attacks which occur on his property." Thus, the court's subtly anthropomorphic language speaks as if the hospital, and not the criminal, had committed the assault. Now, I would like to conclude by observing that as a matter of social policy, the Fleming-James-Roger Traynor conception of tort law is demonstrably wrong. Recent scholarship by such professors, George Priest, Richard Epstein, and others, documents the fallacy of the breezy assumption that insurance markets can function adequately when the courts are imposing unlimited tort liability. The recent liability insurance crisis provides a graphic illustration of what can happen with a tort system run amok. Some of the social costs of the current liability mess are as follows. First, important goods and services are unavailable or costly, such as vaccines, daycare centers, the cleanup of hazardous waste. Second, the economic impact of all of this is regressive. The benefits of a plaintiff's judgment are greater for high-income plaintiffs, and yet the costs passed along in goods and services are equal for the poor purchaser as for the rich purchaser. And third, the transaction costs are enormous. Most of the money spent in the system goes to line the pockets of lawyers. Less than half of it trickles down in net compensation to the plaintiffs. However, there's a more fundamental problem with the Fleming-James-Roger Traynor experiment, besides the fact that they were just wrong as a matter of social policy. They were even more wrong to hijack the common law in the service of their peculiar vision of social policy. I have no particular objection to worker compensation legislation or no-fault automobile insurance enacted through the democratic process. But that's the way social policy should be made in our system, not by the courts fiddling around with the rules of the common law in order to serve their social objective. Now, I realize that it's sometimes difficult to distinguish in a common law adjudication situation between what is serving social policy and what may be a legitimate exercise of the flexibility of the common law. But I would submit that what the California Supreme Court has done in the area of tort law far transgresses any reasonable line that can be drawn between the two spheres and represents the antithesis of the common law method, and instead the unbridled exercise of judicial activism in the cause of social engineering. Thank you.
Judge Mosk.
Thank you, Mr. Reynolds. I appreciate the opportunity to meet with a group of Federalists and with these distinguished panelists. In baseball, the American League now has a so-called designated hitter. Somehow I have a suspicion that I may become the designated dartboard for this session. In view of what happened to the Supreme Court of California last November, as you undoubtedly know, 3 of my colleagues were resoundingly rejected by the voters. There are only 4 of us remaining. Losing nearly half of our population probably justifies putting us on the list of endangered species. I'm to talk about the decision-making process. I can't limit myself totally to the common law because California is a code state, and indeed most American jurisdictions now are. That means that their law is codified. Anyone can find it in a book. But I hasten to add that our legislature and most other states also have declared that whenever the codified law does not cover a subject, the common law shall prevail. So we do look on occasion beyond our codes to the common law, sometimes back to its origins in England. But common law is not static. It's adaptable to changing conditions. Let me give you an example. In a case called Rodriguez versus Bethlehem Steel Company, we faced the issue of a wife suing for loss of consortium. Her husband, through the alleged negligence of the defendant, had been reduced to a limp vegetable. The plaintiff contended that as a result, her role had been altered for the remainder of their lives from wife to nurse. Now, the common law developed during an era when a wife was merely the chattel of her husband. She had no personal rights other than those existing vicariously through her husband. A majority of the states, including ours, abandoned that subservient role for wives, overruled past precedent, and held that a wife did indeed have a right to claim a loss of consortium. In so doing, we observe that the common law is not a codification of exact or inflexible rules for human conduct, for the redress of injuries, or for protection against wrongs, but is rather the embodiment of broad and comprehensive unwritten principles, inspired by natural reason and an innate sense of justice, and adopted by common consent for the regulation of the affairs of men. Now, the inherent capacity of the common law for growth and change is, I think, its most significant feature. It is constantly expanding and developing in keeping with advancing civilization and new conditions and progress of society. Now, that's nothing new, nothing startling in that statement. The United States Supreme Court said the same thing back in 1884 in a case called Hurtado versus California. The court said, this flexibility and capacity for growth and adaptation is the peculiar boast and excellence of the common law. Now, that vitality can flourish if the courts remain alert to their obligation and opportunity to change the common law when reason and equity demand it. Now, here's another example. In 1966, we had a case called Mon Jaris versus Newton. It involved a school board that provided transportation to all its pupils in rural districts, except for 10 youngsters living in one rural area. Now, this was clear discrimination against those 10. We could have pronounced constitutional violations, equal protection, perhaps due process, but we simply declared there was an abuse of administrative discretion. Now, on the other hand, we could have looked back to English common law and found a duty to serve. Professors Charles Haar of Harvard and Dan Fessler of California Davis recently wrote a book called The Wrong Side of the Tracks, in which they tracked the common law duty to serve back to land use law in 13th century England. Now, many of those early cases involve ferries, that is boats, not people. Ferries were, of course, an obvious necessity for getting from here to there when there was an intervening body of water, excuse me. Maybe something Freudian in that. Now, if the ferry operator enjoyed a monopoly and suspended service or charged excessive fees, there was a serious impact on the economic life of the area, and that was harmful. Thus, there was born this common law principle in 13th century England that enterprises providing essential services to the public have a common law duty to serve, an affirmative obligation to provide all citizens within their geographic area equal, adequate, and non-discriminating access to those services. Now, in modern application, if a school board elects to provide transportation for its pupils, it cannot deny bus service to some of them, barring unusual circumstances. If a utility is given a monopoly to provide electricity to a city, it cannot provide service to every house on your block except yours. It has a common law duty to serve all. Now, it's a small jump from that principle to the result we reached in the Bakke case. I had the opportunity to write the Bakke opinion for our court. I still believe ours was better than the result reached by the United States Supreme Court. Alan Bakke, you will recall, applied for admission to the medical school at Davis and was rejected in favor of a number of minority applicants whose objective qualifications were inferior. The justification was a quota system. We held three things. Bakke had to be admitted, the quota system was invalid, and race could not be considered as a factor in determining admissions to a public university. The Supreme Court agreed with us on points 1 and 2, but Justice Powell held for a majority of 5 that race could be one of the many factors in the valuation process. Parenthetically, I must tell you that for 4 solid years, I was apprehensive that Bakke would give up or flunk out of medical school. One of the happiest days of my life, I think, was the day that he graduated, and the class gave him a standing ovation at his graduation ceremonies, and he won an internship to the Mayo Clinic, and he is now practicing medicine in the state of Minnesota. Now, if I were writing the Bakke opinion today, I would give serious consideration to adapting the common law duty to serve. The University of California at Davis is a public institution financed by the taxpayers, and it must adhere to its duty to serve without discrimination, not only against, but also without discrimination for any persons because of their ethnic origins. Now, does that mean an end to affirmative action? To me, the proper role of society is to take reasonable steps to equip all persons, particularly youngsters, for life's competition. If more training is required for some because of racial or language barriers, or because of a handicap, a physical, family, or economic disability, then more training ought to be given to them. But once the competition begins for jobs, for promotions in employment, for educational opportunity at the higher levels, everyone must compete on the basis of complete equality. No one should get out of the starting blocks ahead of the others in a democratic society. Now, having spoken of the common law as if there is such a readily ascertainable body of law, let me revert for a moment to the views of Oliver Wendell Holmes. In 1928, in Black and White Taxicab Company, Justice Holmes said that there is no such transcendental body of law outside of any particular state. The fallacy and illusion, he said, consist in supposing that there is this outside thing to be found. Law is a word used with different meanings, but law in the sense in which courts speak of it today does not exist without some definite authority behind it. Then, of course, there's the most famous Holmesian quotation from an earlier case: "The common law is not a brooding omnipresence in the sky, but the articulate voice of some sovereign or quasi-sovereign that can be identified." Now, if Holmes was right, and there really is no common law that we can put our fingers on, what is the governing law? Is it what was attributed to Charles Evans Hughes, that law is what the judges say it is? I hope not, and I think not. Some courts and some judges occasionally forget it, but the law is what the representatives of the people say it is: the Congress for the country, the legislatures for the several states. And that doctrine is what distinguishes our country from others in this troubled world. I'm reminded of a capsule lesson in social science I heard recently. In England, everything is permitted except that which is prohibited. In Germany, everything is prohibited except that which is permitted. In Italy, everything is permitted, including that which is prohibited. In Russia, everything is prohibited, including that which is permitted. And in this country, the distinction is often blurred between that which is permitted and that which is prohibited, and often it doesn't seem to make much difference. I'm going to have to skip because of the limitation of time. Perhaps we'll have a discussion that may answer some of the other points later on. I do want to point out one thing very briefly, and that is the constant debate, particularly in multi-judge courts, as to whether they are courts of law or courts of justice. For example, one may have a perfectly valid claim on a contract. He should win a judgment in a court of justice. But statutes require that he bring his lawsuit within 4 years. One day over 4 years, he loses that just claim in a court of law. So we have to keep in mind that distinction between a court of justice and a court of law. And finally, just one last word. There's a substantial portion of society these days that expects courts to be responsive to public opinion. The executive branch of government, the legislative branch of government must be responsive to the will of the majority. Why not the judiciary? If we really want a judge to decide innocence or guilt of an individual, or whether the constitutionally guaranteed rights of an unpopular religious, political, or racial group are to be curtailed on the basis of public opinion, I would hope not. It would be a sad day for individual merit in this country, if a judge feels he must take a poll of public opinion before rendering a judgment. If that day comes, let's put George Gallup on the Supreme Court, and we'll get public opinion with reasonable certainty. Judges do have to be fearless and independent, unafraid of applying the Constitution and the laws to the least among us. That, I believe, is what was contemplated by those who fought British tyranny and then fashioned our Constitution 2 centuries ago.
Thank you, Judge Mosk. Judge Rees.
I would like to begin by assuring Justice Mosk that I personally agree with him strongly on at least one thing, which was that the California Supreme Court's opinion in Bakke was better than the United States Supreme Court's opinion. I would caution him, however, against thinking that as a guarantor of Alan Bakke, his problems are over when he graduates from medical school. They're just beginning. The old saw about lawyers who write title opinions don't sleep for 30 years, it seems to me applies equally well to those who, after all, are a cause in fact of a particular doctor's operating, perhaps negligently at some future time, on a plaintiff. I had some doubt about why I was chosen for this panel. I think that it's because I have written articles in which the words common law appeared within 5 words of each other on the Lexis search. All the writing and really most of the thinking I've done about the common law has been about the use of common law techniques and the application of common law ideology to constitutional and statutory interpretation. My primary concern has been to show that these techniques, and especially this ideology, are largely inappropriate when applied to the task of interpreting a document. That the notion of what the judge said last, what the last judge said, is relevant, highly relevant, perhaps the common law techniques and the common law ideology tend probably to impede the notion of statutory and constitutional interpretation more than we know, insofar as they atrophy the devices that would otherwise be used to figure out what things mean, insofar as they distract attention from the primary sources of law and from the exercise of trying to figure out if there's such a thing as a meaning in a document. Now, in the process of bashing the common law in what I take to be its most important application for society today, which is as a method of constitutional and statutory interpretation, I have always assumed, for the sake of argument, that the common law actually works where it was originally supposed to work. That is, that where the law is openly judge-made, where there are certain areas that the legislature has left to the judges for adjudication and for elaboration of principles, for application of principles in particular cases, that it's a good idea, and that indeed judges can do justice according to law in those kinds of cases. But I have been a moderate on that question, as I am on most questions about which I know very little. It's important to keep a few things where you can be a moderate. And now I have to speak about it. I have had a year now, almost a year, as a judge in a jurisdiction whose caseload is small enough that you do have the luxury of thinking about your opinions. I have sat in 20 or 30 trials and in some appellate cases, and like it or not, you do wind up doing a little thinking about whether the exercise you're supposed to be engaged in is a worthwhile exercise, although less than you might think. I was, on my way back here the last time I was in the States, I had a conversation with somebody who knows something about the law and the jurisprudence in American Samoa about a rather arcane point of having to do with our admiralty jurisdiction. And I began to get that same feeling that I would get when I was a law professor talking to a colleague who just wouldn't understand and acquiesce in my point of view. It's very frustrating. And I had told him several times in every different way that I could think of, and he was still hewing to his position. And at some point in that discussion, it occurred to me that it didn't really matter whether I convinced him or not. And a tremendous feeling of calm came over me. That is what is wrong with the judicial enterprise and with the notion of judges as the consciences of the community. What is the task of a judge in a common law case? In a case in which we acknowledge that the law is going to be judge-made one way or the other. What is the judge supposed to do? The task has been most often defined lately being the past 50 or 60 years, as to provide for change in society and in the rules that govern society within a framework of continuity. That was the thesis of Justice Cardozo in The Nature of the Judicial Process, and it has been the thesis of most of those who have come after him. I believe that as thus defined, the common law doesn't work very well. That is to say, it doesn't work as well as the principal alternative, which is the civil law, or law primarily by statute, with the judge primarily as a messenger, trying to figure out what the statute means in each case. I don't think it works because I don't think judges are particularly good at figuring out when it's time for a change. I think that legislatures are better at figuring out whether it's time for a change. And although it's true there's lots of inertia and there are lots of reasons legislatures don't act, I guess that's where my conservative bias comes in. I don't think that's necessarily a bad idea. I think that if you want continuity, there's nothing like a statute. There's nothing like a written law that puts people on notice from age to age about what the law means, and that lay people as well as lawyers can find easier than they can find the meaning of the rule against perpetuities. And I believe that change can be adequately provided for by legislatures. In my belief that the common law doesn't work very well and has lots of bad side effects as a method of providing continuity, a change within a framework of continuity, I can cite the most often praised example of the common law doing that, which is the line of cases that began with a case called Winterbottom versus Wright, and that ended in what is almost always called, in the traditional Homeric epithet, Justice Cardozo's masterful opinion in McPherson versus Buick. Now, this case involved technically the meaning, this line of cases, involved the meaning of a term, the term dangerous instrument. And at the beginning, in Winterbottom versus Wright, almost nothing was a dangerous instrument. The importance of that was that you could only recover for negligence against somebody with whom you did not have privity of contract if what he had made was a dangerous instrument. Otherwise, if the thing went berserk and killed all kinds of people, only the person who'd bought it from you could recover. And in Winterbottom versus Wright, they decided that a carriage wasn't a dangerous instrument. Almost nothing in those days was a dangerous instrument. Guns pretty much were. Guns and poison. By McPherson versus Buick, though, there was a whole line of cases, and in the end, McPherson was the case by which basically everything was a dangerous instrument, because the definition of a dangerous instrument became when something in the manner used is likely to cause harm. And since by definition you always have got a case where in the manner used it caused harm, almost everything turns out to be a dangerous instrument by the time of McPherson versus Buick. Now, in between there were some awkward moments. There was a time when, according to the cases, a boiler that exploded and killed some people was not a dangerous instrument because it wasn't designed to do harm, unlike a gun and poison. However, by some cases, including both some previous and later cases, a coffee urn and a seltzer bottle were dangerous instruments because in the manner used they had obviously been likely to cause harm, that is, in the defective manner in which they were in fact used. But those awkward moments were all resolved by McPherson versus Buick. He used all the common law techniques, pointing out that some cases really weren't the leading cases and therefore didn't matter, distinguishing some cases on their facts. And McPherson, to this day, I think, is taught in the law schools as an example of the masterfulness, the wonderfulness of the common law. What McPherson and the whole line leading up to it stands for to me is the notion that the common law has a way of making the names of concepts the only thing in which there has to be continuity. The contents of the concepts are absolutely disposable. Everybody says, isn't it wonderful that he never overruled any cases? Isn't it wonderful that that notion of dangerous instrument was still around as a kind of security blanket? I don't think the people in the cases even knew whether it was a dangerous instrument. If it was a security blanket, it was one for lawyers and judges. But isn't it great that the concept itself never changed, and yet it adapted to suit the needs of modern society in which there were automobiles? I don't think so. I think that the most obvious thing about Justice Cardozo's opinion in Winterbottom, in McPherson, as well as a lot of the others, is that they didn't tell the truth about what they were doing. And that is really kind of an essential element in most of what turns out to be called masterful about the ways in which the common law provides change. I don't think that's a good thing. I don't think it's a good thing, first, because it violates a commandment, and second, because it plays havoc with the role that I think judges ought to play in a democratic society. And I will tell you what that role is in an effort to rehabilitate the common law in the 5 or 10 minutes that remain. The other justification and the other model of the judge's role has been suggested by Friedrich Hayek and others. The reason that Hayek thinks that the common law is good, that common law decision-making is a good way to operate, is that the common law is like a market, and anything like a market is good. The common law is like a market in that the decisions about each case are made by the person, or at least by the decision maker, with the most facts about each case. That is to say, the legislator can try to think of all the possible cases, but he can't possibly think of all the cases, and therefore he can't possibly make a statute that really will cover all the cases. The judge only has to decide one case, and he has got all the time he needs, he's got all the resources he needs to find out, as well as anybody is ever going to find out, at least before there was the exclusionary rule, what happened in that case. And that is that truth-seeking, fact-finding function is what the judge is good at. It's what he's well situated to do. Now, it might not work, because after all, the judge isn't like a market. He's not like a consumer in some ways. He's a government official to begin with. He's doing a kind of central planning, even if only for his little district. And the litigants don't have any choice where they go. There isn't, so what if the judge has the information? If he's a despot, or if he's a lawyer and therefore doesn't think like a regular person, maybe the fact that he happens to have all the information doesn't make any difference. Maybe he's not going to succeed in his enterprise. However, I think that that's where every system depends on its personnel and depends on what you tell the judge. Hans Linde, in the constitutional context, has written a very brilliant article in the Yale Law Journal 13 years ago, suggesting that the law does have an instrumental function, that it has a symbolic function, that it has a teaching function, that maybe the main thing the law does is provide an example for society, provide reassurance to different elements in society and so forth, but it stops doing that when the judges start trying to do it. Good adjudication is like breathing. You can do it perfectly well, but only when you don't think about it. And therefore, when the legal realists told judges that their role was to do what they thought was right for society, instead of to decide individual cases, to do justice within the framework of whatever rules happen to have been provided by the legislature, to do justice in the particular case, not only did they stop doing justice in particular cases lots of the time, they stopped having the instrumental function that they were trying to have. I think that if I can close with an analysis of Richard Willard's cases, what Richard thinks is wrong, it seems to me, or has said is wrong, with most of the cases, with all of the cases that were cited, is that in each one of those tort cases in California, there was a principal wrongdoer who wasn't available, didn't have a deep pocket, and therefore, for that reason, the court found somebody else and found them liable. Now, whether I object to the result, and particularly whether I object to whether I have the systemic objection that Mr. Willard seems to make to those cases, depends on whether I know more facts. And I want to pose one hypothetical, which is that the hotel at this very moment is giving the key to Richard Willard's room to somebody who claims to be his brother and says he very much needs to get in the room. When the person has stolen all of Mr. Willard's things, Richard sues the hotel since he can't find the other people. Now that partakes of all of that's got the basic problem in it that all of those cases had, and yet I at least think that he should recover, although I'm not saying how I would decide a particular case if it were before me. As a general matter, as a matter of general philosophy, I think he should recover. And why is it that I think he should recover? Well, if I were writing the opinion, I would have a number of different things I could say about that, and my basic point is whichever ones they are, I should say it. I should decide that case as I think just, if there is no statute forbidding me to do so. And I should either say, I think that Richard should recover because the hotel was morally blameworthy in the following ways, or because, although not morally blameworthy, they could easily have prevented the problem and did not, or because the hotel has insurance and Willard unfortunately doesn't, or because the hotel has a lot of money. Now, within all of those reasons, I could be right or wrong, but I would not be violating the Hayekian role of the judge in any systemic way. If, however, I decided that we should, and I think this may be Willard's primary criticism, if I decided that the hotel should lose, that Willard should win, because hotels generally have a lot of money, even though this one doesn't happen to, or because hotels generally can get insurance, even though this one unfortunately has allowed its insurance to lapse. And then if I don't even admit that that's the reason, and I say something else, I'm committing both of the sins that get in the way of the judge performing that information function. I'm not telling the legislature, which may want to change the rule, what the rule really is. I'm not telling future judges who may want to be influenced by my decision what the decision really is. And insofar as people suspect that I am being dishonest, and eventually people do, I am bringing discredit, at least to the man at least in the eyes of the man in the street, on the judicial role. So it seems to me that if we would redefine the common law, do judges have to care about public opinion? No, but in a sense they still have to be the consciences of their community. That is, they have to try to do justice, and they have to have some idea of which of their own ideas about justice are idiosyncratic and which really partake of the views of the people in their community, and that it might be a good idea to leave areas like tort law, in which it's impossible to make all the rules in advance, to those judges to decide each case according to its particular facts and to say so. Thank you.
Thank you, Judge Rees. We now have about 10 to 12 minutes, and I think rather than doing a rebuttal of the panelists, they can answer through responses to questions that any of you have. We have two microphones in the middle of the room, and if people would line up and use the microphones and direct their questions to any one of the panelists who they want to have a response from. That's probably the most efficient way to do it. All right?
I just have one question, one comment. There are two problems in the court system right now. One is urinalyses in the workplace and surrogate motherhood. I think you'll all agree nobody could write a decent statute covering those two difficult problems. You need the courts and bright lawyers pointing out different degrees in different situations. But neither of those problems could be solved by the legislature. It would be judicial decisions with bright lawyers, like I say. The other problem would be, my thinking is that the common law does not cause change, it simply responds to new situations. For example, the ultralight, the windsurfer, the surrogate motherhood, or the urinalyses in the workplace. New social situations come by and we have to respond. So the common law, as opposed to Judge Rees, it doesn't cause, it reacts to social situations. And I would also comment about your example with the hotel. The common law had strict liability, innkeeper's liability, so Willard would win under the old common law. But it's been modified with limitations of liability under the statutes of different states. But going back to my first comment, the courts do have that function with those problems that I mentioned. Thank you very much.
When your first comment, I thought you were saying those were the only two problems in the court system, urinalysis and the other. I don't agree with you. I think that courts frequently cause change as well as react to it. And I think that, I don't, however, in the common law area, think that's as bad as I suspect some conservatives might think it is. There's a model that I really abhor in the constitutional context about how the court is having a dialogue with the American people, and it sort of proposes a rule, and the people react to it, and they accept it. Well, they usually can't do anything else because they need 3/4 of the state legislatures in order to change it, or they need a new court. And so the dialogue model falls flat on its face in the constitutional context. I think in the common law context, it makes sense if the judge is being honest. I think frequently the judge has to choose, even if he thinks that he's got to choose the rule, which is the sensible rule that a person would apply, a reasonable person in society. He winds up with 2 or 3 different options. And I don't have any real problems with the judge in a case that has new circumstances in it, deciding in favor of the rule he thinks best and saying what his reasons are, even if it does conflict with a precedent laid down in the time of King John, as long as he's scrupulously honest about the reasons. If the case is controversial, it'll be overruled by the legislature. It may be overruled by the legislature, and he shouldn't be offended. He shouldn't take it personally. He does have a role in that dialogue, but I think it's naive to think that all courts do is respond to change circumstances. Certainly they help change the circumstances.
I've been asked if each person would identify who they are before asking the question.
I'm Gary Lawson. This is addressed specifically to Rocky, but I would welcome anyone's comments on it. You expressed the suggestion that legislatures would be better able to identify circumstances in which there is a need for change than common law judges. Let me distinguish between 2 kinds of change. Change that is needed and change that interest groups contend is needed. I can see how the latter would be more likely to be recognized by legislatures. But in all seriousness, is it really true that there is reason to believe that they would be better suited at identifying the former kind?
Well, that puts me in mind of an article by Harry Wellington, who made that same argument, said that courts are better for that reason, that legislatures are subject to interest groups, and courts are not. They have all this insulation and everything. But then he said, well, where do you look for your sources of law? And he said, the American Law Institute, because that's not an interest group. My problem is that I think courts merely respond to different interest groups, perhaps a different slice of society. As I said once in criticizing the common law, any method of interpretation by which a 4-wheeled vehicle a parakeet could be a 4-wheeled vehicle isn't a method of interpretation, but the common law could achieve it if you had intervening cases involving a horse-drawn carriage, a horse, and an ostrich, and if there was sufficient anti-parakeet sentiment at the Yale Club and in the Times. I think we've got the problem whichever way we go. I think if we're just talking about what changes are needed, I would trust legislatures more than I would trust judges. Now, that's of course not true in the case of the High Court of American Samoa. But if the judge doesn't get to be me, I will cast my lot with democracy as far as deciding what changes out of all the different ones we could have are appropriate.
Good day. My name is Mark Redlich. I'm from Cambridge, Massachusetts. And I'd like to direct the comments to the panel, but I'd like to comment and ask a question about what Richard Willard was speaking about. The question of whether decisions are good or bad has often been addressed by lawyers, by our professors in law school, and certainly by the legislature at times. Isn't what you've been speaking about today a part of a process that we're all involved in? That is, we all know about the pendulum swinging back and forth. We know if it goes too far in one direction, the judges, the appellate courts, or the legislature will act. The insurance liability crisis is one of those situations. I don't think anybody claims to know all of the truth and have it all. I recall William James saying in The Meaning of Truth that truth is ambulatory. You sort of approach it and walk up to it. But isn't that what you've been talking about here? An effort to find the truth, to find justice in particular cases, and in general theories of what the law should be doing in certain types of situations.
Certainly at one level that's quite true. If the courts get the common law really wrong, that's subject being changed by legislatures. And in the tort area, for example, over the last year, 38 out of the 50 states have adopted some kind of tort reform legislation to rein in the excesses of this liability explosion that we've been experiencing. But I don't think that makes it all okay. In part for a reason that Judge Rees alluded to, which is that the courts are not always honest about what they're doing in deciding these cases. Fleming James was fairly honest about his agenda, which was to move to a system in which everyone who's injured gets money, in a system in which the plaintiff always wins. The courts don't do that. As I tried to illustrate, they will still cling to the language of negligence. They will distort the doctrine, as Rocky pointed out. They will find that a parakeet is a four-wheeled vehicle in order to reach a result. And if they're doing that as part of a social agenda, then what they're doing is not really a legitimate part of the process. And it makes the process hard to work properly.
Well, we do have to recognize that there are changes that take place in society that require judges and courts generally to make different interpretations. For example, when the framers of our Constitution said that interstate commerce shall be regulated by the federal government, they intended that to apply to horses and carriages that took days or weeks to cross a state boundary. But courts have had to adapt that principle, that the federal government controls interstate commerce, to airplanes. I came from the West Coast. I crossed 12 states in a matter of 5 hours. That certainly wasn't contemplated by the framers of our Constitution. But the courts have had to adapt the Constitution to that kind of a situation. Now, many years ago, H.L. Mencken, the iconoclast, said the judges have to be masters of both the microscope and the telescope. What he meant is that we have to look to the letter of the law, and we have to also look to the pattern of the law.
Thank you.
One more question.
Last question for Judge Rees. I found your remarks heartwarming. I think all litigators find them heartwarming when a judge praises candor. But I'm confused by a suggestion in your remarks that a candor perhaps excuses undue creativity or undue legislating on the part of the court. What's your view of the telephone booth decision? Justice Bird was quite candid in her footnote that Mr. Willard quoted regarding the availability of insurance by the telephone company. And you also suggested that the insurance factor was one which might influence your own decision in Mr. Willard's hypothetical case against this hotel. Because of candor and because of the insurance factor, do you think that that decision was a wise one?
Well, no, I would disagree with the decision. The candor solves one of the systemic problems that I was referring to. It doesn't solve the other one, and I still reserve the right to think it was wrong. I didn't say that I would be influenced personally by the fact that there was insurance. I tend to be kind of a moralist in tort matters, but I do think that that admitting it gets over one of the problems. You're giving accurate information to the public and to the legislature and to other judges about what the facts were in your case that influenced you. Now, the other problem that I referred to is whether she is in fact paying attention to the facts of this case, or just generally saying, we know the telephone company has insurance and this poor man and poor people who get hit don't. If she's doing that, then she is not being true to this model of judicial decision-making that I suggested. The judge has no special moral claim and no special duty to legislate for all of society for future cases. And he has no special expertise about what the facts are going to be in future cases. Analogizing to the consumer again, the judge who decides based on what influence he wants to have on future cases is like the consumer who, instead of buying a polka-dotted tie because he wants one, does so because he thinks it would be fun if the manufacturers were fooled into making more polka-dotted ties. He is in fact causing the system to be dysfunctional. He's sending wrong signals. And I don't think that she necessarily was deciding, I haven't read the case, but it sounds like she wasn't deciding because there was insurance in that case, but because she in general thought this would be a good idea in future cases. Now, even after you've done that, you can disagree in the result, but then you don't have a systemic problem. You just would decide differently if you were the judge.
Let me, if I may, give you a couple more facts about this horrible example A. So that you don't have the idea that this is the old story, the man who fell in the river and complained that the river shouldn't have been there. You assume these additional facts and then see if this is such a terrible decision. The telephone company had known that there were previous accidents that took place in this same area. And secondly, most significantly, at least to me, was the fact that as the person was using the phone and saw the onrushing car, he tried to extricate himself from that phone booth, and the faulty door of the phone booth prevented him from extricating himself. And as a result, he was seriously injured.
Thank you very much, members of the panel. We can all give a round of applause to the panel members.